All right.
We hear from, or perhaps we can, maybe we'll hear from Mr. Hussain first. Yes.
The short point to which I'm responding, Your Honours, is why is it that my client did not issue an SBLC to its own company, Emirates Moon, and then utilize the funds, issued a manager's check and made the payment. The short and simple answer to that question, Your Honour, is that we have, as per the terms of the contract, this is the only manner in which we could have made the payment. And second, the seller, we never had a discussion with the seller in terms of amending the terms of the contract to include a new method of payment. But coming back to the very critical point, it is very difficult when we are issuing the SBLC, making a request for the issuance of an SBLC. It's very difficult to explain it to the financial institution that we are both the issuer and also the beneficiary of the instrument.
Two different companies? Two different companies?
They're definitely different companies. Ownership is the same. And in this, and if you see the first, our 3rd June SBLC, although we had transferred, Your Honours may note that we have issued it to ourselves, and that was the principal objection of the other side. Although we issued that SBLC to ourselves, to our company, Emirates Moon, but we had written there the purpose was purchase of 72 apartments, which means even though this was given to us, it was transferable to them, and only they could have taken the money. I could not have taken that money. So, in the first SBLC, Your Honour, it is very clearly written that I am the beneficiary first, Emirates Moon, and it says that it is transferable. However, in the same thing, it is written that it is for the purchase of 72 properties, and the beneficiary is DIFC. This is how that SBLC is worded. So we were able to do that because we showed that beneficiary is different than the issuer. In UAE, with the banking system, we have a problem if I have money somewhere else in some other part of the world, and if I transfer, the purpose for which the money is to be transferred is very critical. And after all, SBLC is a guarantee. So it's very difficult to convince the financial institutions that I am the issuer, I have money here in this country, and I'm the beneficiary of this instrument, and this is my purpose. That's why we chose this method. And for this purpose, let me take you, since this question has been raised, to the tab 8 bundle 2. If you don't mind, Your Honour, this is a very important point. Which is
Bundle 2.
Bundle 2, tab 8. This is the first witness statement of Akbar.
Yes.
Bundle 2 is here, and this is at page 1 108.
Yes.
And I'm referring to para 17. Therefore, although my company, Emirates Moon LLC, was the beneficiary of the SBLC, it could, this is the point I was trying to tell the court, it could not avail the SBLC as it was not the owner of the 72 units in New Bridge so-and-so Motor City. The only entity that could avail the SBLC was the claimant, and the claimant could easily avail the SBLC by submitting the title deeds and the contracts to Masjid Bank. I did not have title deeds and contracts to the Masjid Bank. If I open an SBLC in my own name, I need to explain the purpose. It's a question of explaining to the financial institution and convincing them to issue an SBLC. This was an easier way to explain the purpose was buying 72 apartments. They would produce those documents and SBLC could be honored. This was the purpose, Your Honor. And if I may also take you to one important, just 2 points which I forgot to mention in my presentation this morning. They're also at tab 8, and I request you to move to page 113. Just
hang on a minute.
Just before we go.
I'm just looking at what you're saying is going against the very nature and essence of a letter of credit, which is basically an instrument that works on documents, not on the underlying transactions, right? So the bank just says, who is the payee? This is the person, and if he complies with the conditions of the letter of credit, then they have to pay unconditionally. All they're looking for is compliance with the terms. The purpose may be stated for information, but that's not a condition of the drawdown. Anyway, go on.
Your Honor, coming back to page 109.
Same bundle.
Same bundle.
Yes.
We move to page 109. And I'm referring to paragraph 27. I want to bring this point to your attention. I did not bring it earlier. I was, in the meanwhile, trying my best to resolve the issue and make the payment as soon as possible to ensure that the transaction goes through. On 3rd August 2015, the claimant presented the security check in the bank and returned the same, asking to be presented after 3 working days. As soon as I was made aware of this event, this is the point, in good faith, although my check was wrongfully deposited and dishonored, to ensure that they received the money equivalent to the security deposit, and in order to protect myself from liability, I immediately issued another SBLC. I issued a second SBLC in favor of the claimant for an amount equal to the value of the security check on 14th August 2015. The SBLC issued on 14th August 2015 was very specific as to the reason why this SBLC was issued. This SBLC was issued instead of security deposit of 10% as part of the total cumulative deposit with check number so-and-so of so-and-so. On 18th August, I issued a second SBLC in the name of DIFC Investments election for an amount of 107 million towards the total purchase price and all government costs involved in this transaction. The point to be noted, Your Honor, is that after my first SBLC, because my first SBLC was not referred to the beneficiary and it was sent back to the issuing bank. At that time, in good faith, after my check was deposited, I immediately opened a second SBLC from the issuing bank explaining the purpose equal to the value of the amount on 14th of August. And subsequently thereafter, on 18th of August, I immediately made a payment of 107 million, which is again the price. Now, both these SBLCs where the bank, which was the correspondent bank, again if you will see here, at that time these facts were not known to us that there was some compliance issue, there were these issues because of Interpol, because of that. So we thought that when this SBLC was returned to us, we thought we should reissue it again. Maybe the first did not go through, the second one would. And once again we blocked this money, which we issued, and this SBLCs were presented. The issue with those SBLCs was that the account number was wrong in one of the SBLCs, and there was another issue in that regard. But the point that I want to convey to the Honourable Court is that we made every single effort on our part to tried to make the payments in whatever way we could. And the fact that we issued the second SDLC again shows our intent. And the reason after we issued the second SDLC, it was not possible for us to issue a third SDLC to ourselves, because what happens is, this money that we have, which got locked in, again I cannot arrange the second amount of money to pay to myself.
But why couldn't the first standby you haven't heard my question. Why couldn't the first standby letter of credit be issued in the name of the seller, DIFC Investments?
The first standby letter.
Why did it have to be issued in the name of Emirate Moon?
That we have explained and I have read out to you. The reason is because that standby letter of credit is like an instrument which they can use once issued. Because they had not obtained the NOCs, and we obtained the NOCs only on 14th June. This SDLC was issued on 3rd of June. So we, on 3rd of June, to show our intent that we want to proceed with this transaction, we issued this SDLC to our company, showing them to them that this company is transferable.
But there was no law that says you cannot issue a standby letter of credit even before the NOC. You just hold on to it.
The thing is, the arrangement with the other party was that we will pay you through a standby letter of credit. Now, we could have waited till the NOC.
The standby letter of credit was meant to be encashable immediately upon presentation.
That's correct.
So it's up to, and you were supposed to give it to them when they got the NOC. But that was just a contractual arrangement between you and the bank. There was nothing to stop you, your client, from establishing a standby LC in favor directly of DIFC Investments, and just hold on to it. In exchange for the NOC, you give them the standby LC. That was what was supposed to happen.
I think this point was the only intention on our part, Your Honor, was not to dishonor the situation or anything. Only point was because we were not sure if these NOCs will actually come. So to show our good faith.
Then why open this dummy standby letter of credit? It's of no value.
Its value is that it is transferable and it is confirmed by the bankers. The SPLC was capable of
Why go to the trouble of transfer when you just cancel it and issue a new one in the name of the proper payee, proper beneficiary?
I'm afraid at this point in time, I don't know. I did not pose this question to my client.
Right.
So I may not know what he must have thought at that time by taking this decision.
But you agree that there was no lawful impediment to him issuing the standby letter of credit in favor of DIFC Investments from day one?
The only thing I could presume, Your Honor, and I may be, please pardon me if my understanding is not accurate, the only thing I could presume, Your Honor, is that perhaps they were under the impression that this is a relationship between the banks once an SDLC is opened. It is the issuing bank that will correspond with the correspondent bank, and the correspondent bank has to advise the beneficiary, and once the beneficiary presents the documents, the money will be immediately paid subject to discounting. So perhaps the client may have thought in his wisdom of things that when SDLC is transferable, why should I commit to this amount or to this SDLC, not having been fully advised? I am sure if he was fully advised in this regard, he would have taken the decision as the court has just referred to it. But I'm not sure, Your Honor, to be very honest with you, what transpired in the mind of my client to have done that. But I could only defend his action by saying that his intention was a good intention on his part, thinking how people in this part of the world think, who are, when they come up with this huge chunk of money, they feel, I will not give you until you give me this, you give me this, and I'll give you that. I mean, perhaps these are not.
Is your client a resident here? Is your client resident in Dubai?
Now his residence visa has expired. He's no longer.
But at the time of this transaction, he was a resident of Dubai.
I have to verify this point, Your Honor.
Okay. All right, Mr.
Out of curiosity, where is your client now?
Still in jail, isn't he?
Well, he's not in jail. I believe he is somewhere.
So he's finished serving his sentence?
He has not finished serving his sentence. And he is waiting for an opportunity so that he could prove that the check was wrongly presented. And this criminal, that is, in fact, Your Honor, now that you pose this question, this is the, on the equitable side, where I don't have any provision to cite, where I don't have any legal case to cite, but this is the main issue in this particular case. We need an opportunity to knock the doors of this court, simply to come out. Even, for example, if this honorable court were to say, are you ready to perform the contract? Do you have this kind of money? Would you be in a position to make this, open a new SPLC and make this payment? Perhaps my client would not say no. He would readily accept, because what that would do to him is he would have an opportunity to come out of this arrangement. Assuming that he is holding himself in good faith, this is what he would expect to do. But I know for a fact that if the judgment comes that he has terminated, this contract stands terminated, he won't have another forum where he can go to say that the check was wrongly presented.
So are you telling this court that the real purpose of this appeal is to avoid your client going to prison?
Sorry, Your Honor?
Are you telling the court that the real purpose of this appeal is to avoid your client going to prison?
No, that is not the real purpose of this appeal. The real purpose of this appeal is to point out the legal provisions in respect of the judgment that was passed, and I've confined myself only to that. But on the equitable side, I'm saying the consequence and effect of delivering this judgment, one of those consequences could possibly be this.
And has he been sentenced to prison?
He has been sentenced for 3 years, Your Honor.
In absentia, so he's never actually been into prison? Because he wasn't here to be taken to prison.
Let's say he's here and he hasn't been to prison.
Right. All right. Okay. We understand.
Thank you very much. Mr. Prakash Joyce, please recommence.
Well, on that last point, Mr. Zia does provide an address in his first, second and third statements, which are respectively to be found in bundle 2, tab
Just
8.
tell us what they are.
Apartment 2411, Burj Khalifa, downtown, PO Box, etc., Dubai. And those are February and April of this year. Now, in our submission, the court will be assisted in relation to the submissions that the learned friend has just made by looking at the contract, which is in bundle 1, tab 4, page 28. Clause 3 of the contract, Your Honours, deals with the payment terms. Clause 3A deals with the security deposit. Clause 3B deals with the payment of the principal sum. And it quite clearly says that that sum shall be paid by manager, cheque, or any other guaranteed method of payment that is acceptable, etc. So, Your Honours, if one returns to the question which was posed, why was it not possible for the defendant to take the monies in cash and complete the transaction? In our submission, the answer is it was possible.
Well, that's a bit too simple, isn't it? Because it does go on as follows and then sets out a specific mechanism which involves the issuing of a letter of credit on the date of receiving the NOCs, but one that can be cashed immediately. And it's an LC in favour of DIFC. So there's a very specific provision. Whether you say that that's merely by way of example,
Well,
or what, I don't know.
In my submission would have to be by way of example, because what it is doing is giving an example of an other guaranteed method of payment. Because what is described...
Alternatively, taking a standard provision and adding a specific. But as follows doesn't suggest simply an example, does it?
can one equate an SDLC, which is very specific and clear, with a manager's cheque, which in my submission, they are different creatures. So that when one comes on to the particularity which has been added, it does look as if it's particularity in relation to the other guarantee method of payment, rather than covered by the manager's cheque. But we can't take it further, but in my submission, the manager's cheque was specifically raised, and it is important that the court should be aware of the full provisions of clause 3b, at least contributing to the answer which is to be given to the question that was posed by the Chief Justice before short adjournment.
Well, the reality was that what took place didn't accord with either.
Yeah.
The point that was made about the NOC is that under the terms of the contract, it was only after the NOC was received that the letter of credit had to be opened. So it could have been in favour of DIFC as the clause itself required.
Yes, the point which should be able to yes.
But reading this again, this contract, paragraph 3 speaks about the buyer agrees to pay the seller total deposit of 10 million for cumulative price of 105 million. But then paragraph B speaks about the sale price of 1 billion something. And then it spells out also how the payment is to be made. I think I'm just following what Justice Cooke was just mentioning just now. What is that? What is the relevance of the 1 billion?
I think that this of course is only one example of 72 contracts which were in standard form, so that the total sum for all of the 72 properties was the 107 million dirham. And that this is looking at payment for the specific contract in question. And then there would be 71 other examples in relation to the other properties. So I think that is the answer to Your Honour's point.
And it also spells out the method to who to be paid to as well.
So the deposit is the same sum mentioned in each of the 72 countries because it is the cumulative deposit.
Exactly.
And then the price is actually lesser because it is broken down to the price of the individual unit.
Yes.
Doesn't sound like that. I don't know what the Arabic translation, the Arabic term says.
Yes, carry on, please.
Unlike the second aspect of homework, which I hope I largely anticipated, was why federal law. And perhaps I can just give the court some cross-references in support of submissions I've already made. I've already taken the court to clause 17, which is in the document we've just been looking at, namely Bundle 1, tab 4, page 29. We've looked at the effect of Article 272 of the UAE Civil Code. That is for, again, the court's reference, Bundle 3, tab 26, page 367. And that requires the giving of notice, but in our submission, the extension from the 7th of June to the 18th of June, clear requirement that payment be made on that date, and that extension by express agreement between the parties constitutes notice, or that in conjunction with clause 6, which we've just been looking at the foot of page 28, constitutes notice. And of course, under Article 272, that does not specify the form of notice, so long as notice is given.
Sorry, say that again.
Yes, Article 272.
Yes. No, but before you mention it, what is it that you say constitutes notice?
Well, the fact that the parties agreed on or about the 7th of June, on the express date of the 18th of June, and that of itself, or in conjunction with the terms of clause 6, which everyone's familiar with, so I won't take the tribunal to again, that constitutes in our submission notice.
Well, I think there's an important difference between the two alternatives you pose. If all that clause 6 says is we agree that the completion date shall be whatever it is, X, then that's all that the contract says. And if you simply say, well, we now agree to extend the completion date, it doesn't change the nature of the obligation that is stated in clause 6, which could be construed in one way as a simple conveyancing clause, which does not try to encapsulate any implication of time is of the essence. If your contention is that the clause itself makes time of the essence, then of course when you extend it by 1 month, then time remains of the essence on the renewed completion date. The renewed agreed completion date. But if the original clause was simply the same clause as appears in every run-of-the-mill sale and purchase contract for property, which is the price is so much and we agree to complete on a certain date, then you need to have a notice to complete after that if you miss the first completion date. Right? And in this case, if clause 6 was a run-of-the-mill clause fixing simply the date of payment, the date of completion, then you don't have a notice that makes time of the essence, as far as we can see in the subsequent correspondence.
Well, Your Honour, that was why we place emphasis on the express agreement to extend beyond the original contractual date of the 7th of June, which originates from the standard form that we've seen at tab 4. It takes it out of the standard form context into a bespoke agreement between these two parties.
Can we have a look at it again? I don't recall any wording in that extension letter that changed the character of the agreement in clause 6 into a different type of contractual relationship.
Now, my reference to this is in Mr. Parik's evidence, and let me find Mr. Parik's evidence, which is bundle 3. Looks at bundle 3, tab 19. Paragraph 16E. What he says at paragraph 16E is all procedures and requirements to transfer the properties were to be completed by the 7th of June 2015. And that is with express reference to the capital C contracts, as one can see in the opening couple of lines to paragraph 16. Sorry, I should have given the page reference, it's 274. And then when one goes over the page to 275, at paragraph 90, he says it became clear that the transfer of the properties would not be able to be completed by the 7th of June as a result of delays in obtaining the no objection certificates. Although DIFCI would have been within its rights to terminate the contracts, it nevertheless agreed to extend the date for completion of the transfer at Mr. Zia's request. Therefore, in early June 2015, the parties agreed a variation to the contracts, whereby it was agreed that the date for completion of the transfer would be extended to the 18th of June. Otherwise, the relevant terms of the contract remain as set out.
Exactly. It doesn't change the nature of the agreement between the parties, which is fixed by clause 6. If clause 6 was a run-of-the-mill completion date fixing clause, then this extension keeps the character of that clause, unless there's something in the letter that changes that.
in our
The
submission,
effect of clause 6.
it keeps the clause as is, save only as to time, and that was extended by express agreement and at the request of Mr. Zia. And there's never been any difference between the parties over what was said in that regard.
Exactly. So what I'm saying to you is this: it is perfectly normal in a straightforward conveyancing contract, price so much, completion date so much. And that clause is not a time of the essence clause. And it's also every day that, sorry, we can't complete on this day, can we postpone it to next week? Yes, here's a letter, we postpone it to next week. It's still a run-of-the-mill completion date clause. Unless your second letter says, we've agreed to extend it at your request and this is the final extension we're going to give you. And it's a drop-dead date.
Ronald, may I take the court to Bundle 1, tab 6, which is the IFMAR capital decision of Sir Anthony Colton.
But the reality of your case turns on clause 6, doesn't it?
Well, it does.
Quite simply, you say that the seller has the right to terminate the contract, given if these events happen. And you say that makes time of the essence, and you're either right or wrong about that, and that's the beginning or end of it, isn't it?
And we seek to make that good by reference to the paragraph in
Very good.
Which is exactly the point that I think is common ground between us.
We've got ISMA. Give us the
IFMAR is tab 6 in Bundle 1.
You're there.
Could I take the court internally to page 71 and paragraph 72 and 73? Given the circumstances in which the MOU was entered into, sorry, and I'm ahead of the court.
Slightly, yeah.
Paragraph 72, Your Honour. Given the circumstances in which the MOU was entered into and the volatile nature of the market for office property in the DIFC area, as well as the structure of the MOU, I conclude that on its proper construction, clause 7 provisions as to the deposit check are such that they require strict compliance, and that such compliance is of the essence of the contract. The Contract Law 2004 does not intend to precisely replicate English contract law's concepts of conditions, any breach of which entitles the innocent party to terminate the contract, or in nominal terms, breach of which may entitle the innocent party to terminate the contract if the consequences of the breach are such as to deprive the innocent party of substantially the benefit it was anticipating he was entitled to derive from performance of the contract. Instead, there is Article 86.2, which prescribes fundamental non-performance as the yardstick for entitlement to terminate the breach. The example of breaches of contract which regard is to be had as amounting to fundamental non-performance and which are, in my judgment, to be construed disjunctively include B, breach of an obligation calling for strict compliance, which is of the essence under the contract. It is unnecessary for there to be an express statement that compliance with the terms of the essence of the contract. It is sufficient if, as a matter of construction or trade practice, this is implied. That it should be implied in this instance is supported by English law cases with regard to deposits under contracts for sale of realty, see Millichamp and Jones, United Scientific Holdings and Bromley Borough Council, and under contracts for the sale of goods, Otaria Shipping, and in the analogous case an obligation to the buyer to open a letter of credit, Nichium Corporation and Gutterwell. I therefore conclude that IFMAR's failure to provide a manager's cheque by way of deposit on the date upon which the MOU was signed did indeed amount to a fundamental non-performance of the MOU.
If we're looking at clause 7, we'll find that at paragraph 10, won't we?
We do, yes.
Looking for the clause 7 provision that he was looking at. It's
Yes.
page, paragraph 10, page 54.
Indeed, because that is a continuation of a recitation of the clauses which begins back in paragraph 7.
And that had no provision for termination at all, as such.
No.
Just simply said they had to provide the
Which clause in that?
7, do you see? Paragraph 10.
Yes,
Third one down is 7.
7.
That's the relevant clause. I mean, on the face of it, not a terribly strong clause, one wouldn't have thought.
Indeed not. And I suppose the final point in this regard that I should place before the court, though in my submission, the submissions I've already made dispose of the point in favour of the respondent. Of course, when one looks at the relief sought in the claim form, this can be found in Bundle 3, tab 17, at page 266. The remedies were sought in the alternative, a declaration that the contracts as executed were terminated in effect from the 8th of July 2015. Alternatively, a declaration that the contracts are terminated by the court.
I'm sorry, just give me the reference to what you're talking
Bundle
about.
3,
Bundle 3, yeah.
tab 17. Claim form begins at page 265.
Just before I forget, before I leave the ITMA case, homework again. Can you send to us copies of the cases that you just cited by Sir Anthony Coleman?
Yes, certainly.
I mean, I recognize at least one of them, which is the United Scientific Holdings case. And I think I vaguely remember the Millie Chamberlain Jones.
Yes.
The reason why I don't ask for the other ones are because in shipping cases for sale of goods and in letters of credit cases, very often the nature of the obligation being undertaken is such that the law will deem time to be of the essence. You know, when you're shipping perishable goods out, time is very, very important. LC also depends on time. Whereas the other two look like property cases, so I'd like to have another look at the property cases as applied by Sir Anthony Coleman, who whatever his great genius lay in wasn't in wasn't in conveyancing. Now, so if I could have those cases
Yes,
later on sent to us.
Do that as soon as practicable.
No hurry about that. There probably will be other homework as well when we finish at the end of the day. Yeah, sorry, now you're going to take us something?
I was taking the course to Bundle 3, tab 17.
But tab 17, isn't it? Yeah, okay.
And this is the claim form, Your Honour, where at 266, under the remedy sought, Your Honours will see that the declaration was sought in the alternative. Either that the contracts as executed were terminated with effect from the 8th of July 2015, alternatively, a declaration that the contracts are terminated by the court.
And what is the order made by Justice Oba?
He found that the contracts were terminated as of the 8th of July 2015. And we say that he was correct in so finding.
You know, if you go on the alternative line of the applicable law being federal law, article, is it 272, was it?
Yep.
We were looking
Yes.
at? Then the contract remains alive until the court terminates. So what does that, where does that put your client with regard to all of the events that happened after the 8th of July?
Well,
On your case, that the applicable law is the federal civil law.
yes. We say that if you look at the combined effect of 267, 268, 271, 272
Of the
UAE Civil Code,
civil code.
that what happened You apply that law to the facts that we've looked at, and our primary case is that the court of first instance was absolutely right to find that the termination had taken place on the 8th of July 2015. And it gets, we say that the proper approach in law is to apply UAE rather than DIFC law.
But I don't understand the UAE Civil Code to say that if the court declares a contract terminated, it declares it terminated with retrospective effect. Doesn't it declare it going forward? Which is why I asked, if you have to wait until you get to court, then until you get to court and the court releases everybody from its obligations, then the contract still stays on foot, in which case the inquiry into the factual conduct of the parties will carry on after 8th of July, perhaps up to the point of coming into the court.
Well, Your Honour, in my submission, in our submission, the answer is to be found in Article 271.
Okay, wait. Then we're really going to go look. Have you given us 271? Do I have to go and look in Whelan?
It's Bundle 3, tab 26, page 367.
Bundle 3?
Tab 26, page 367.
Having found the bundle, I've forgotten the reference now. Which tab?
Bundle 3, tab 26, page 367.
And you wanted to look at 271, was it?
Article 271, Your Honour, yes. It shall be permissible to agree that a contract shall be regarded as being cancelled spontaneously, i.e. automatically, without the need for a judicial order, failing performance of the obligations arising thereout, and such agreement shall not dispense with notice unless the contracting parties have expressly agreed that it should be dispensed with. So either the parties have agreed to dispense with notice in the circumstances of the express agreement to extend time from the 7th to the 18th. That constitutes, on the facts of this case, notice. And therefore, under Clause 6, the combined effect, together with Article 271, is that what is permissible under Article 271 has indeed occurred.
No, I'm sorry, I don't understand this. Your request for relief is twofold and in the alternative. Either under the DIFC contract law, you want an order from this court to declare retrospectively that what you did on the 8th of July was legally correct. You are shaking your head.
No,
I misunderstood you.
Yeah, because our case, Your Honour, is that UAE law applies.
No, but I'm starting with the first limb, which is one alternative. And the second alternative was that the court declares it terminated, which is what I thought was the remedy that you seek under UAE law. You asked this court to declare it with effect from the date that Judge Umar was hearing the case.
No, we have always said that in our submission, UAE law is the applicable law, albeit that the DIFC courts exercise jurisdiction. And under UAE law, we say that we are entitled to a declaration of termination as of the 8th of July 2015 under Article 271. And as a fallback long-stop position, we say that we are entitled under UAE law under Article 272 for a court order terminating the contracts now. But to make good the submission that I've just made about our case on what is the applicable law, may I take the court back in the same bundle to tab 22, which begins at page 313.
Same bundle?
Same bundle, tab 22, beginning at page 313.
By the way, I think you were misquoting. I think you were misquoting the article, because I thought you first referred me to Article 271, but in your last statement you're saying 272.
I say that 271.
I understand your but 271 is one alternative, and the other alternative is that you actually want the court to declare. And the one that you want the court to declare is under which section?
Well, that would be under 272. Sorry.
No,
no.
That's why I'm puzzled.
No, my apologies. It's not 272. It is 267. It's 267, which refers to the order of the court. My apologies. You're absolutely right.
So my question was, if you did it under Article 267, then doesn't the court declare it terminated as from the date of the pronouncement of the court? So until and unless the court declares it terminated, the contract still exists, even if one party is in breach. In which case, then your prayer for relief that the court declares it terminated as from the 8th of July technically may not be correct. It would only be from the date that Judge Omar made his decision.
Well, we say that the earlier date flows under UAE law from Article 271, and that when one looks at Article 17, which establishes what is the applicable law, and looks at Clause 6 and the further extension of time, which was a bespoke agreement between the parties, that we are within Article 271 for a termination on the 8th of July 2015. In the alternative, we say, well, we can't have the no man's land continue, so therefore the alternative is the 267. You are absolutely right when I referred to that, erroneously to 272, the 267 order of the court. And if I may... But
the order of the court will only be with prospective and not retrospective effect.
Well, if the court itself declares that the contracts have been terminated, then it would be from the date of that declaration.
Yes.
But if the court is declaring, making a declaration as to what is the extent, rights or otherwise of the parties, then that would go back to the 8th of July. And that's how the alternative operates.
Okay, let me not detain you. Carry on. You wanted to show us something?
I wanted to take the court to Bundle 3, tab 23, which, beginning at page 313, is the claimant submissions, so DIFC investment submissions, on the applicable law and prevailing language. Leave aside prevailing language.
Did you say tab 23?
Tab 22.
22, right, thank you. I'm there.
At the foot of page 313, applicable law pursuant to clause 17, and I've taken court to clause 17, and then over the page, paragraph 4, in the claimant's view, clause 17 makes it clear that it is UAE bylaw, not DIFC law, that is applicable to the contracts. The learned judge has asked the parties to consider in light of Article 3 whether UAE civil and commercial law has been disapplied because the claimant is a DIFC entity. Then Article 3 is set out, and the particular reference to financial activities is the definition of financial activities for present purposes is set out in paragraph 6. Paragraph 7, the contracts in question in this claim do not pertain to financial activities as defined in law number 8. Moreover, Article 3 of law 8 does not prohibit a DIFC entity from selecting the UAE civil and commercial law, from selecting, I think there's a superfluous that, does not prohibit a DIFC entity from selecting UAE civil and commercial law in its commercial contracts. Then we have DIFC law number 10 of 2005, And these laws are at the end of this bundle. So the court has DIFC law number 6, the contract law, behind tab 25, and the DIFC law number 10 behind tab 27 for the court's reference. DIFC law number 10 provides part 3 applicable law on the contracts, and then article or section 14, the law of in relation to the law governing rights in property, the law of the jurisdiction where the property is located. And that applies both to the law governing rights in property and the law governing the validity of the transfer of property. And then going over the page, 315, the contracts are subject to this claim pertain to the sale and purchase of real property located in Motor City, which is outside of the DIFC. Pursuant to Articles 14 and 15, any contract relating to the transfer of interests in that property must necessarily be governed by the laws of onshore Dubai and the UAE, including the UAE Civil Code. Therefore, pursuant to Article 8 of that law, any consideration as to the existence, validity, effect, interpretation and performance of the contracts must also be in accordance with the UAE Civil Code. Further weight to this proposition is given by virtue of DIFC law number 3 on the application of civil and commercial laws, which provides under Article 7, 7b, that the object is to allow persons to adopt the laws of another jurisdiction in relation to civil and commercial matters arising within the DIFC. The application, looking at Article 8.2, the relevant jurisdiction, then A relates to regulatory content, not in our submission relevant in the present circumstances. But B, the law of any jurisdiction other than that of the DIFC, expressly chosen by any DIFC law. C, the laws of jurisdiction as agreed between all relevant persons, and that takes us back to clause 17. And then one goes over the page to paragraph 11, where 7b is specifically commented on, but I don't think I need to detain the court further in that regard. And then paragraph 12 is a statement of the claimant's position. It is therefore the claimant's position that, based on the foregoing provisions of DIFC law, the properties the subject of the claim are located in Dubai, outside of the jurisdiction of the DIFC, and in accordance with Articles 8, 14 and 15 of Law 10 of 2005, are subject to the laws of that jurisdiction, that is, non-DIFC laws. The law stated to govern the contracts is UAE local and federal law, as applicable in Dubai, which by its nature is not DIFC law, DIFC laws being Dubai laws.
Pause there a minute, I don't quite understand that last sentence. When you say which by its nature, I don't know what its refers to, because there are two laws cited. And if DIFC laws are Dubai laws, aren't Dubai laws local laws? UAE local law?
Well, I think that may be why the word federal has been underlined. And I think it was underlined
so it's local and federal, so as applicable, surely?
Well, in our submission, one has to read it as a whole, UAE local and federal law.
But by definition, the two are different. So if the two are cited together in the same phrase, doesn't it imply that where federal law has application, you apply federal, and where local law applies, because of the constitutional relationship, of internal emirate laws versus federal law, then you apply whichever is applicable under the overall scheme of UAE legal architecture?
In our submission, for the reasons which we've set out in paragraph 12a, local law in this context must mean onshore Dubai law,
yeah,
not DIFC law.
So I shouldn't take that phrase DIFC laws being Dubai laws as read. I mean, it's slightly misleading there.
Yes, I think
in the context that you want.
I think it's probably superfluous for present purposes.
Okay. All right, carry on.
Pursuant to Article 7 of Law 3 of 2004, the parties are entitled to adopt the law of another jurisdiction in relation to civil and commercial matters within the DIFC. And then, in considering the waterfall provisions to select the governing law found in Article 10 of Law Number 3, 10.2, there is no regulatory contract, there is no law of any other jurisdiction expressly chosen by any DIFC law. Those parties not being applicable, those provisions not being applicable, consideration turns to whether the parties agreed to the laws of a particular jurisdiction. As the parties elected to include the reference to federal law in the contracts, it's clear that the applicable law selected was that of UAE non-DIFC jurisdiction. And that also goes back to what we were looking at in the earlier paragraphs that I've already read. In any event, it is the UAE federal and local Dubai law, non-DIFC law, which has the greater connection to the properties, the subject of the dispute, by virtue of the fact that the properties are not located in the DIFC, and the registration of the contracts and other procedural matters would be required to be done through the Dubai Lands Department, which is a non-DIFC government entity.
Yeah.
So
I follow you, that's fine.
Unobliged. And then what we've done for the sake of completeness, but I won't trouble the court with this because you've had an opportunity to read, is we said, well, if we're wrong on that, we have looked at the DIFC provisions under Article 18, particularly 86. We say it comes to exactly the same conclusion, but as a matter of proper legal process and application, we say that the proper course is to apply UAE law, and that, of course, is why we put in our respondent's notice. You'll find the respondent's notice in bundle 3 at tab 23, page 321. I don't invite the court necessarily to look at it now, because what it does is it keeps open the proper law being UAE. Your Honours, may I turn to a few other points which I should probably deal with, and I hope to deal with these quite expeditiously.
Yeah, because I'm just looking at the clock, and ideally if you could finish in about 10 minutes, because that would put you and Mr. Busan roughly on parity in terms of the first round, and then we'll have a second round again after you finish.
I will do my best to keep 10 minutes.
Yeah.
Friend referred to the post-8th of July 2015 situation. And essentially was expressing some surprise or consternation that we, i.e. the DIFC investments, did nothing. Well, of course we did nothing, because we had terminated the contracts as of the 8th of July. So the position that the learned friend puts as being a position adopted is absolutely consistent with the position that we have always maintained, namely termination as of the 8th of July 2015. And in this regard, may I take the court to our skeleton argument in B3, tab 24, at page 341. And as the court will see, this refers to various specific points that the defendant was asserting. You can see that from paragraph 96. And those points arose in August 2015, but there's no material difference between August 2015 and at any time after the 8th of July 2015. As we say in paragraph 98, by August 2015, the claimant was no longer interested in doing business with the defendant, and had given notice by letter dated the 8th of July 2015 that it was not continuing with the transactions. Thus, there was no question of the claimant being required formally to reject the new standby letters of credit. The plain fact was that the defendant was acting unilaterally in our submission, a hopeless attempt to revive contracts which were by then dead. In any event, even if, quod non, the claimant had been interested in continuing with the transactions, the SPLCs were palpably deficient, and I've explained why the new transactions or the new SPLCs, which were unilaterally sought by the defendant, carried the defendant no further.
They were still those payable at expiry, weren't they?
Absolutely. And all of the elements which we looked
Including
at...
the deposit one.
Yes, and all of the elements that we looked at in the manuscript that had been put forward, none of them have been incorporated. Yeah.
No, but the point being made is that it's not quite correct to say you're not interested in continuing in the transaction because there were meetings with your people, as the correspondence shows, post 8th of July.
Well, there were meetings.
And discussions about how to revive.
But nothing was, but we made the point very clearly, we looked at the correspondence before the short adjournment, we made the point very clearly that what was being put forward was something which was unclear to us and which was certainly not part of the original contract. And so that there was absolutely no idea. Yes, we had a meeting and there was correspondence. But that doesn't assist the defendant at all.
Well, all of this is only relevant, I suppose, if the original termination had not taken full legal effect. Then it might be said that he was still at the stage of a locus poenitentiae, where the situation required a firm notice of either you comply with the original terms by a certain date or the transaction is finally closed. Because having said on the 8th of July, that's it, we're not interested, then you kind of entertain at least discussions. So what impression does that give to the other side?
Well, I think if one listens out of civility. When one looks at what was being put back, and particularly the letter of the 25th of August, where we set it out extensively, we get another letter, and then on the 26th of August we write back saying, we've answered these points, no, it's terminated.
Where in your client's witness statements do they deal with the events post 8th of July? Just to see, get the flavor of what their attitude was.
Well, the witness statements are to be found, Mr. Creek's witness statement is bundle 3, tab 19, and he sets out background facts and contracts and then considers the breaches of the contract. Beginning at page, this is bundle 3, tab 19, beginning at page 275, and then he picks up the position as of the 7th and 8th of July, the 8th of July at paragraph 30, page 276. In light of Mr. Zier's breaches of clauses 3A and 3B, DIFCI wrote to Mr. Zier on the 8th of July. Thereafter, DIFC considered itself to be no longer bound by the terms of the contract, as it reiterated in further correspondence to Mr. Zier, dated the 11th of August, the 25th of August, and the 26th of August. Then he deals with the presentation of the security check, which was dishonoured, and over the page. Accordingly, the required payment by Mr. Zier of the total purchase price remained outstanding. Mr. Akbar, whose witness statement is in the next tab, bundle 3, tab 20.
Before you go to that, paragraph 30, at page 276, it says, DIFC Investments considered itself no longer bound, as it reiterated in further correspondence to Mr. Zier. And then it cites 3 letters of August. Are those the 3 letters you showed us?
They are indeed.
Earlier? Okay. Yeah, go on.
And then at tab 20, Mr. Akbar, now his witness statement responds to the first witness statement of Mr. Zier. So we may not get the same level of detail. I don't think there's anything in the course of his witness statement that I should particularly draw to the court's attention in relation, because it's all responding to what he was saying, what Mr. Zia was saying in his first and second witness statements.
Remind me what the application, the CFI application 1 is. This witness statement was responding to the application 1.
Yes. And application 1 was in relation to late filing of an acknowledgement of service.
Okay.
I think what had happened was that the acknowledgement of service had been submitted 1 day late, and we didn't take a point of it.
Mm-hmm. No, I was just looking at paragraph 30 of your client's witness statement there, and we talked about a claim for damages, but in the result, no claim was ever made by Mr. Hussein's client for damages in these proceedings.
Our claim is for the simple declaration.
That's your claim. They didn't claim anything.
Absolutely not. And I will take you up, because before the short adjournment, we raised the question of was there a counterclaim or cross-claim. And I'll take you to relevant passages in that regard very shortly. But absolutely, it wasn't raised.
Okay.
Just to correct a slight point, apparently a point was taken in relation to the acknowledgement of service, but I think it wasn't pursued. Is that a more accurate way of putting it? So we brought it to the court's attention, but we didn't pursue it actively beyond drawing it to the court's attention.
Well, paragraph 26 of the witness statement says that DIFC has consented to the defendant's application.
That was the basis of what I was, my original submission. Yes. It's a very small point. There may have been a temporary equivocation. I think that's what the learned friend was seeking to clarify. But it was only a temporary equivocation. It didn't go anywhere. We didn't object to the late acknowledgement and matter proceeding. The third point that I... Sorry. Yes. The third point is just to deal very briefly with the new case of Hakimzade, which was produced by my friend yesterday. In our submission, Hakimzade, which is to be found in Bundle 4, tab 31, has been misunderstood by my learned friend. Because if one looks at the case of Hakimzade, in particular at paragraph 26, in paragraph 26, insofar as the judgments in the Buckland case were concerned with the effects of the lapse of time, they were talking about a situation of completed action. Insofar as Buckley LJ considered the alternative scenarios of extensions of time, the point was that the dates were fixed dates, were on this alternative scenario of the essence of the contract. In the present case, no new date was fixed at all. So Hakimzade, it is a case where there was no fixed date, and as I've already submitted, the thing was fixed date. It was extended by express agreement through to the 18th of June 2015. The next point that I should very briefly deal with, but it's a point that I think leads nowhere, is, and indeed leads nowhere because of the reasons provided already by the court. My learned friend referred to a reservation of the right to claim damages, but we've not done so. We're seeking a simple declaration,
that actually would mean that you're forever barred, isn't it, from claiming damages?
Well, I can see some procedural hurdles in the way of doing that, but it's not really my position to
certainly in this
concede
court,
that point.
Yeah, in this particular court, if you don't, having given notice of it and you waive it, it's going to be some kind of an estoppel, isn't it?
Well, I can see where you're on coming from. But
that's not our concern.
The case is as it is brought, and all we seek is a simple declaration. Then we come on to a point which I confess I simply don't understand, and that is when the defendant says that he's somehow been deprived of an ability to plead either a defence or a counterclaim or a cross-claim, which of course would be joined. In our submission, he had every ability to pursue any sort of defence or counterclaim or cross-claim, and I think this is most effective.
Hasn't that point gone? Because the point about the inappropriateness of the procedure was the point upon which leave to appeal wasn't given, and the inappropriateness of the procedure was tied up with the wrong idea that defences and counterclaims couldn't be put.
Well, I thought, because of the way in which because the defendant changed his ground, the ordering of his grounds between the commission and the further scanning, it wasn't totally clear to me as to whether the ground 3 on which permission was not granted related to the appropriateness or otherwise of Part 8.
Understood.
I'm the culprit, so I might as well tell you. The reason why that 3 was disallowed because, as I read the facts and as I understand the rules of the RDC, both in law, he was not denied any rights to either defend or counterclaim on any basis he wanted to, and he had already made his remarks about the inappropriateness of Part 8, but then, as far as I could see, Mr. Hussain did not at the hearing pound the table and insist that he wanted to cross-examine anybody in particular on their witness statements. And otherwise, this is a kind of case that we normally hear by way of Part 8, common law jurisdictions, unless there was a really hot issue that needed some kind of oral clarification. So, since he was not being deprived of any forensic disadvantage, and since he was not being deprived of any legal, any factual ability to make submissions on the quality or relevance of the facts asserted by your witnesses, there really was no issue in that particular ground. I mean, it's really on the question of the facts which are largely undisputed or not significantly disputed, and we see the consequence of that in terms of the overall result of events.
Yes, and I'm sure that Your Honour, in considering that point back in July, would have had in mind what the Court of First Instance said in this regard. And I won't read it extensively, but for the Court's reference, the Court of First Instance judgment considers these points at paragraphs 73 and 74, and those paragraphs are to be found in Bundle 1, tab 2, pages 20 to 21.
And he says, in terms?
Well, he refers to the rules of the DIFC court, rule number 837, cites that rule, says the defendant is therefore not prevented from bringing a counterclaim, and goes on to say he has not filed any claims regarding the alleged wrongful encashment of the security check, and I can see nothing preventing the defendant from having done so in these proceedings, or otherwise should he desire. The defendant's informal request for a declaration that the security check was wrongfully encashed was not filed via formal counterclaim, and therefore shall not be addressed in this judgment. Furthermore, all of the filings made by the defendant have been accepted into the court file, and the defendant has not detailed how he's been prevented from presenting proper evidence or what further evidence he requires to make in his case. I referred there to the defendant's informal request. That is to be found, this seems to have arisen simply in the course of the defendant's submission relating to the applicable law and prevailing language of contract, because the Court of First Instance referred to paragraph 38 of the defendant's submission. For the Court's reference, paragraph 38 of the defendant's submission is to be found in Bundle 2, tab 13, page 213. And my learned friend, in the course of his further submissions, namely the submission, an argument in support of permission to appeal. This is to be found in Bundle 2, tab 15, where in the course of the appellant's skeleton argument, at page 243, which is in fact paragraph 19G, he says as follows: the Court wrongly disregarded the prejudice argument by holding that there is nothing in Part 8 that prohibits the appellant from filing its defence or counterclaim. Well, in our submission, the Court is absolutely right in its findings, as I've just taken Court 2. As no counterclaim was filed, the Court wrongly held that it cannot decide the informal plea of the appellant that the security check was wrongly presented. So, even on the face of his own argument, the learned friend accepts that it was an informal request. The learned friend broached Clause 6, and this is fully dealt with in written submissions. But what the defendant or the appellant was putting forward was no cure by way of further standby letters of credit, because a point I've already made submissions on in relation to paragraph 99 of our skeleton argument and orally, the same defects, the same problems were inherent in the second standby letters of credit as were there in the first. And as these raised compliance issues, they would get the defendant not one job further. My learned friend in his submissions referred to an extract from Professor Singh. I'm afraid I'm not in a position to comment because that wasn't in the bundle and I've not been provided with a copy, but I think it's such a small point that I don't feel at any disadvantage. One comes to a point in the submission that I've already made. All we're seeking is a simple declaration, and we can't be left in no man's land. We need to be able to demonstrate clear title to sell. We're not going to get any money from the defendant. He's not in a position to complete on 72 properties. We need to have clear title. We need to be able to point to clear title so that we can sell these properties satisfactorily for the Dubai Lands Department. So,
what's this got to do with title? What has title got to do with the problem in this case?
Well, if any purchaser will do due diligence in relation to the ability of a vendor to provide clear, unencumbered title. And we want to put the position beyond any shadow of doubt, namely that the contracts which were entered into in May 2015 have been terminated.
Okay.
Unless I can assist the court, those are my submissions. In response to my friend's submissions, you have the written argument, which I think has been read and incorporated in the record.
Yeah. Thank you. Since then, see if we can finish in 15 minutes.
Your Honor, I'll try my best only. I guess we have covered most of the issues. And my job in this part, second part, will only be to point out certain key issues and leave it at that. And if there are any questions, I'd be happy able to respond in my written submission if the court asks us to do so. Your Honor, at the very beginning, before I point out to any clause of this agreement. The reason why my client is in a position in which where a proper due diligence and other things will be required, this SDLC that has been issued has not formally been rejected, the two SDLCs. So it is not as if the contracts cannot be performed if things move right. Yes, it is true that we did not file a counterclaim. I am aware it is bound by the instructions of my client. I can only advise the client that this is the proper course of action. But it is not within my competence to move further. If today, whatever is the judgment of this Honorable Court, I only request this Court, if this Court were to look at this issue from a slightly different perspective, even if whatever is the judgment, my right to file an application before this Court, showing the circumstances to the Court, leading the evidence before the Court, to show that the check was wrongly presented, should not be limited by any finding or observation of this Court. It is very important that this my last step, which I have to free myself from the shackles that bind me, should not be taken away. Whatever is the judgment is acceptable, but the opportunity to bring out a claim, because my circumstances are not normal. This is not a normal situation where you go to a client's office or the client comes to your office and you seek instructions or you call the client on the phone immediately and you discuss this as we speak. It takes a little bit of time in these given circumstances. He has gone through a terrible, terrible time, the way he has been. So clearly there should be an opportunity to show us, for us to demonstrate. I have not brought a counterclaim. I have not brought, but I did ask for damages in the question that was raised earlier in my submission, in my claim. I have said that the claimant is asking for damages for the frivolous application under Part 8 that has been filed. The reason I did not touch upon Part 8 procedure is because you have in your judgment very clearly said that appeal is not allowed on this ground, meaning that this is not something that I can argue before this Court. Having said that, Your Honor, I would like to point out a few important issues. My learned counsel, I have just one question for my learned counsel. I understand they argued time is of the essence, and I understand that they say that we are only going to proceed, we have terminated these contracts under UAE law. And I also understand that under UAE law, until the court, either the parties mutually agree or there must be a declaration from the court. And I also understand that unless there's a declaration from the court, the contracts have not been effectively terminated. I think the word is effective termination. I want to ask the question is, why did the claimant wait until January 2017, or rather 3rd or 4th of January 1917, to seek a declaration from the court for termination of the contracts? Time is of the essence. Now, when we look at time is of the essence, it could possibly be a situation where you have another purchaser who is willing to pay a higher price or is available to take these properties, and the proper course would be to immediately seek a declaration from the court. In one of the witness statements of Mr. Akbar, he says that contracts can only be terminated through mutual consent or through the order of the court. He never approached us to seek the mutual consent, assuming that he wanted these contracts to be effectively terminated. In one of the submissions, my
Sorry, did you say that he never approached your client for
seeking mutual consent to terminate the contracts?
I don't think it's alleged that there was mutual consent to terminate the contract.
No, there was no mutual consent, Your Honor. I was just raising a hypothetical argument that assuming that the intention was to clear this up as quickly as possible, one of the fastest ways of doing so would have been to approach us and say, sorry, we're not going to go ahead with the deal, let's mutually terminate this agreement, here's your deposit, and we're going to move forward. But what I'm saying is that even was not done. When my learned counsel says that the contract is dead, in one of his skeletons he read out to us, he said the contract is effectively dead on 18th of July. So there's nothing left there. My point is, the contract, I think this was a question that this Honorable Court posed as well. The contract was not effectively dead if you rely on the ruling of the Federal Civil Court, because the contract will only be terminated once the court has done so. But if the contract was alive, then all the efforts that I have made, which I read out to you in Part 2 scenario, post cutoff date, cannot be simply set aside as not being relevant. They are relevant because the fact that for the second time I opened a second SDLC, it was not an easy thing. There are charges associated with opening a second SDLC. There is an amount of money that needs to be blocked, that which I am paying here for opening a second SDLC. Your Honor, it was not as if I did not make the attempt. In fact, the truth is that the claimant never wanted, when the claimant got a clue from Mashreq Bank that there might be some compliance issues and there is something which we did not know, and there might be some Interpol issues, they never wanted us to be the purchasers. So they did everything else within their control to stop us from purchasing the property. Another important point that I want to bring to the attention of this Honorable Court is, we referred earlier, Your Honor, to an 11th August letter. And Your Honor pointed out and asked this question that on 11th August letter says, DIFC hereby wishes to terminate. Now, I could not go through this letter, simply not that I didn't want to read out those 3 letters to you, but because I realized I had taken too much time. If you look at this 11th August letter, I do not want to take you again because it's fresh in our minds. The letter, as you pointed out, Your Honor, it says that DIFC, they are writing to us that DIFC hereby wishes to terminate, meaning the ongoing negotiations so far are now rejected, meaning what happened until 11th of August 2015, we are rejecting that, we are not taking that into consideration. Now, what we look at is the time period until 11th of August. This letter, dated 11th of August, which says that DIFC hereby wishes to terminate, meaning the first termination was not an effective termination, and precisely the reason why at the second time they're coming up with another termination letter. There was no reference again to the 8th July termination letter. It was not stated that in continuation of my earlier letter dated 8th of July, we are hereby notifying that we're going to we're terminating this contract with effect from 11th of August 2015. This was not done. The third essential aspect that I want to bring to the attention of this Honorable Court is that my learned counsel argued that the SDLC that was issued was substantially defective. In their submissions in all the documents other than the last skeleton, you will see that there is nothing on record where this plea has been taken that the SDLC is sufficiently defective. I want to take you to just 2 paragraphs I bundled to tab 9.
Second witness statement?
Yes, Your Honor.
Of Mr. Zia.
This is the second witness statement of Mohammad Akbar Zia. I have, Your Honor, it's tab 9.
9, okay, sorry.
And this is an email from the banker of the FCI. Now, the issue is, Your Honor, they said that our SDLC was defective. This question was raised. My point is, it says, dear Nadia, SDLC is transferable, is capable of being transferred. The transferee should be issuing a transfer letter to effect the transfer. To avoid the risk for our customer, slight changes made as attached. So the only defective thing one could say is, what the banker is advising them is, we have made slight changes to this and those changes are attached. That does not make my SDLC or my defective. It is not defective. Yes, there were certain changes which they felt they were required, and we were in a position to consider those changes and move forward. Now, coming back to the case that I just referred, Hakimzadeh, I know I'm not able to pronounce it correctly, Hakimzadeh case. The reason, Your Honor, I referred to that case was only to drive two important points. First, if time is of the essence, and if the contract has to be performed by a certain date, and it was, for whatever reason, it was not performed, and if a new date is prescribed, and you say that this is a new date, then before you terminate, and if I'm not able to complete my performance on that particular date, a notice is required. A firm notice that should, and this is what this case says, this is the essence of this case, that a firm notice that if you do not complete your obligations by such and such date, we will hereby terminate the contract. I need to be on notice. That notice was not given. In fact, Your Honor, the first extension, Your Honor referred to the first extension, where my time limit was increased from 8th to 18th. In fact, there is no such, we don't have on record any extension letter that was granted to us, as no extension letter has been produced before this Honorable Court, insofar as that first extension is also concerned. And in that
but that was not denied. As a fact, it was not denied.
As a fact, it was not denied. But it would have been helpful if that extension letter was there, in which it would have been stated that this is the new cut-off date. It would have been helpful to know, assuming that such an extension letter was there, that this is the full, your performance is needed by such and such date. So, with regard to another point, an issue was raised was the original clause which he referred to, clause 6, clause 3b. You know, where you referred and you asked, the Honorable Court asked my learned counsel that was this a run-of-the-mill clause? I want to point out to this Honorable Court that what you see as the sale and purchase agreement, my learned counsel pointed out in one place where it said manager's check and SBLC. Now, I want to refer to Form F, which I have here on record. And if you refer to Form F, you will see identical language there, manager's check or any other form of payment acceptable to the Dubai Land Department. So it was not as if, I think the party's intention to enter into a contract has to be seen. In cases where there are contracts which are provided by the regulatory authority, in order to have, so that there is uniformity in the system, what is contained, unless those contracts are substantially varied or amended, the inference cannot be derived from those contracts that refer to this clause of this contract, and there is an intention that time is of the essence. Specific language needs to be incorporated because those contracts have been drafted by the regulatory authority for every civil person who wants to enter into a transaction with you to provide them the guidance. So we cannot rely on that provision, which is identical to the provision in Form F, and say that parties intended that as per clause 6, if you do not perform, and if you do a combined reading, as my counsel said, by a certain date, the contract shall stand effectively terminated. I beg to differ. That cannot be an argument that can be taken.
But the other fact that the SBLC was given not in the claimant's name.
Sorry,
the SBLC was not made out in the name of the claimant. There's another point that was raised by.
Yes, in the beginning, this was the question that was raised was, why did you make the SBLC, the first SBLC of 3rd June, in the name of your own company, Moon Trading, and not in the name of the defendant? And my only short answer to that question, Your Honor, was, at that time, and no objection certificates were not issued, and we were not sure if they would be issued. And
yeah,
so
isn't that also a breach of the terms of the agreement?
Well, you can say that, well, there's one point, Your Honor. Assuming that there was no transfer clause contained in the SBLC, that would be the correct proposition, that would be the correct interpretation of the law. But because it was done with information to the other party, that I have here my drawn up an SBLC favoring you, but in the name of, in my company's name, which will be transferred to you upon this event. Now, what they did was, as I've shown you from the evidence on record, they accepted that transfer. So assuming that there was a breach, assuming for the sake of an argument, but not conceding that there was a breach, they accepted that. They waived that breach. The breach was waived once they accepted that. So coming back to the substance of what I want to say, I want to draw the attention of this quote to one critical point, which is the purpose of filing this appeal is to bring to the attention of the court that my rights under Clause 6, which is the agreement of the parties, were completely overlooked. The facts and circumstances that pertain to Clause 6, the application of Clause 6, were not considered. The Clause 6 is a penal clause. It is nothing but a retention of earnest money, and it uses the word violation, it uses the word act or omission, unless I have done something intentionally, recklessly, with a view to cause, with a view to breach the contract, or with a view not to perform my obligations under the contract. That interpretation may possibly hold ground that you are in breach of Clause 6. But if I have not done so, I cannot be penalized under Clause 6. If I cannot be penalized under Clause 6, my security deposit, and I appeal to this court, I'm not sure if this is but court has the extraordinary powers. Under its extraordinary powers, I'm just requesting the court, because I have presented the circumstances before and evidence before the court, if there is a possibility for this court to exercise its extraordinary powers and request the opposite party not to return the security deposit for the reasons that I have explained. And assuming that it is not possible to retain the security deposit, may I request the court to look at this as a penalty clause and look at the measure. They have not shown any loss which has been occasioned as a result of that. Maybe award an amount that we have to pay which is lesser than what is contained in of 10% of the amount, because my client's position is not at this current the way he is to take care of this, because he needs to come out of where he is. So if this relief is possible, please grant me this relief. If this relief is not possible under extraordinary powers, please lower this amount to a reasonable sum, so that we could mutually terminate this contract, and we agree, and we can pay penalty to some extent, assuming that this is the only option left.
But that is for your other reason, I assume, the reason that was supposed to
Sorry. Right now, as I understand it, your security check bounced, so they are out of pocket, or in the sense that they haven't taken your security deposit. So there is no penalty effectively in force. They have committed themselves only to asking for a declaration, and Mr. Joyce will admit that there may be some problems if he later on brings another claim against your client. And if he brings another claim against your client, at that point certainly you will have a defense that you want to raise about penalty. So, this court doesn't seem to have that on its agenda. Is this something that we can't decide?
Forgive me for saying so, but I conclude from what you are saying is a follow-up of what Justice Cooke asked you this morning. That the real reason is to get your client out of the other problem.
No, Your Honor. Your Honor, you are absolutely correct. It may appear, by virtue of my pleading before this honourable court, that this might be my main objective. I cannot.
Because if you look at dollars and cents, they're not getting any single cent from you. They've got lost something. So if both can walk away, you could have not lost anything. They have lost something, but they're not claiming from you. Just walk away and finish off. But you are still persisting on this for, I don't know, whatever reason, unless what you're asking for the contract to be affirmed and to be enforced. which you're also not asking for.
Well, Your Honor, that was before the lunch break. In my submission, I requested the court. I said, well, if this court were to consider and say that perform the contract and ask for a specific, suppose ask the other party to specifically perform, I'm sure the SBLC that we have opened, the money is still blocked. It has not gone anywhere.
But you're not asking us for that one.
I am, Your Honor. I asked for this relief in the just before lunch. This was
But it was not before the judge at first instance.
It was not, Your Honor.
So
Your
there's
Honor,
nothing
Judge,
on record from you asking for specific performance or a declaration that the contract has been wrongfully terminated and you want damages. I mean, either you want specific performance or you want damages as an alternative. You have not actually formally claimed that.
Your Honor, if specific performance damages we have claimed, it's written in our submission. We can share it with you.
Submissions before the judge?
It's submissions before the court of first instance. We have a reference to damages. I will just show it to the Honorable Court.
Which is not dealt with is it dealt with by the judge? Or did he simply say, well,
because
since
I have not brought a counterclaim, Your Honor, I have not made any cross application
well,
of.
if you raise damages and you don't claim it, then there is no counterclaim. Unless you pleaded it as a set-off.
Bundle 2, tab 10. Page 165. Now, I may have given a different reason for the damages. At that time, my claim before this court was the same, identical, but it was also because certain material facts were not brought to the attention of this Honorable Court, which only came out subsequently in the 3 witness statements that we submitted. So I asked the court.
Your claim for damages is only based on procedural irregularity by the other party, by the claimant. It's not based on any rights under the contract. I'm looking at page 167 because at 167 you formulate your proposed draft order, which I presume was not granted. And to the extent that you filed a claim at all, it was not a claim for substantive damages based on the claimant's misbehavior or breach of contract, right?
Your Honor, when I say that claimant shall pay damages for withholding material facts and information from the court, I am trying to say that the other party did not bring all the relevant information before the court.
I know, but that's a procedural matter. It's not a substantive cause of action.
That is
under
correct.
the contract.
Your Honor, I stand corrected here. Yes, I have not mentioned it.
Because your relief is all procedural.
I mean, if it's any relief to you, if and when the claimant chooses, elects to bring another claim against your client for damages for breach of contract, then you will have your defense, I presume.
Yes, Your Honor. Your Honor, that's correct. I have not mentioned it.
I mean, right now, as my learned colleague is saying, I mean, both parties are walking away. I mean, your client is out of pocket for the expenses that he's incurred on this transaction, but you haven't even claimed that.
Well, we have asked for costs, legal costs and other expenses.
But that's only, again, of the procedure, not of the transaction. So
yes, we have not brought an effective.
You didn't ask for specific performance. You didn't ask for breach of contract for wrongful termination.
That is.
Let's just leave that.
Yes.
Are you done with your rebuttal?
Yes, I have summed up my.
Thank you very much. Ms. Patrick, I think you can be quite short.
Your Honor, yes. I think there's one point that I should draw to the Court's attention, and that is, of course, the issue in relation to the bouncing security check is a matter of which the onshore Dubai criminal courts are seized. And that's where matters rest. You know the nature of our claim. I think, by way of rebuttal,
the nature of your claim for what?
Our claim is for the simple declaration, which is set out in the remedy set out in the claim form, which I've taken the court to, and carried
But the
over
fact
into
that
the previous
there's a
claim.
criminal prosecution doesn't disentitle your client from a civil remedy of damages at the appropriate time.
Yeah, well, and all I can do, instructed about at appellate level, is to argue within the four corners of the case which we have brought, and
Right.
that's all I'm doing.
Yes, okay.
Your Honour, apart from referring to the fact that the bouncing of the security check is before the criminal courts, really, my role, I only have lockers to say anything. If the learned friend has said something new which hasn't already been dealt with, and in my submission, anything that has been said which is new has already been dealt with. Therefore, I have nothing further to say.
No, I think that's. I think Mr. Sam was, I think, really sort of re-emphasizing the points that we have made earlier. So I don't think we need any particular reply from you at any particular point, apart from the items of homework that we have indicated to you. I think we have no further questions or remarks. What are we going to do about costs? So we're going to ask for a cost assessment, Lima, on this basis?
Submissions have been made, haven't they?
They have made submissions. Okay, right. So we'll take that into account. So when can we have the matters requested? Not really. Should be quite quick, isn't it? Within a week or so.
Oh, I would hope. I'm going to try and do with it tomorrow.
Right. Fine. So in that case, we will. Well. I don't think we need any submissions from either of you, unless either of you want to make submissions on the two cases that I've asked you for, and you want to make any further submissions on the case that was submitted at the last minute today. Why don't we do it this way? Why don't you leave it, give us the cases. If we need any assistance, we will tell you.
Yes.
Right.
I will provide copies of the cases referred to in paragraph 72 of IFMAR, both to the court in hard copy. Would you also write it in soft copy form as well?
Yes.
Hard and soft copy form, and I'll make arrangements to do likewise. If another friend's happy with just in soft copy form, we can probably do that more easily. We will do that. Soft copy is fine.
I think soft copy all round.
Soft copy all round.
Yeah, we'll make copies from that or
I
forward.
I will do that as soon as I practically can, and if the court wishes for any further submissions in the light of those cases referred to by Sir Anthony Coleman in paragraph 72, I will be more than happy to respond, and I'm sure that...
Well, why don't you give us the whole lot of cases?
Okay.
Yeah, Sir Anthony. Yeah.
I would like that.
Yeah.
All rise. You don't need to send them to the hard copy. They will probably just take them back electronically anyway.
Well, that's not what I thought.
So